Question 1. While investigating inconsistencies across various units, a federal antitrust regulator discovers that several pharmaceutical companies have entered into agreements delaying the release of generic drugs in exchange for monetary compensation. The regulator is tasked with determining whether these agreements violate U.S. antitrust laws. Which of the following best describes the legal principle applicable to this scenario? 8. These agreements are per illegal under the Sherman Act because they involve horizontal restraints on competition. B. The agreements are subject to the rule of reason analysis to determine if they have anti-competitive effects outweighing any pro-competitive justifications. C. Such agreements are protected under the Noah-Pennington Doctrine as they are related to government petitioning activities. D. These agreements are exempt from antitrust under the State Action Immunity Doctrine. Answer. B. The agreements are subject to the rule of reason analysis to determine if they have anti-competitive effects outweighing any pro-competitive justifications. Explanation. This scenario deals with pay-for-delay agreements which arise when a brand-name drug manufacturer compensates a generic drug company to delay the market entry of a low-cost generic alternative. The Supreme Court addressed this issue in Federal Trade Commission v. Actavis Inc. 2013, ruling that such agreements are not per illegal but must be evaluated under the rule of reason. A. Incorrect. While horizontal agreements to restrain trade can be per illegal, the court has held that pay-for-delay agreements require a more detailed competitive effects analysis rather than outright condemnation. B. Correct. Under rule of reason analysis, courts examine the anti-competitive effects of the agreement, potential justifications, and whether there are less restrictive alternatives. C. Incorrect. The Noah-Pennington Doctrine protects from antitrust liability when lobbying the government, but it does not apply to agreements between private parties restricting market entry. D. Incorrect. State action immunity applies when states explicitly authorize certain anti-competitive conduct which does not apply to private pharmaceutical agreements. This question helps candidates analyze how antitrust laws apply to the pharmaceutical industry and highlights the distinction between legality and the rule of reason in evaluating competitive harm. Question 2. In a situation where formal requirements conflict with business efficiency, a major technology platform implements a policy that prioritizes its own products and services over those of third-party sellers on its online marketplace. Several small businesses file an antitrust lawsuit claiming that the platform is engaging in monopolistic behavior. Under U.S. antitrust law, which of the following factors is most relevant in determining whether this conduct constitutes an illegal monopolization? A. Whether the company possesses monopoly power in the relevant market and has engaged in exclusionary conduct. B. Whether the company has the largest market share in the industry regardless of other factors. C. Whether the company's policies benefit consumers by offering low prices and improved service. D. Whether the company operates internationally and faces competition from foreign markets. Answer A. Whether the company possesses monopoly power in the relevant market and has engaged in exclusionary conduct. Explanation. This scenario examines self-preferencing by dominant platforms, a key issue in technology and digital markets. The Sherman Act, Section 2 prohibits monopolization when a company has monopoly power in the relevant market, it engages in anti-competitive conduct that excludes competitors without a legitimate justification. A. Correct. Courts analyze monopoly power, market share, barriers to entry, and ability to set prices, and whether the company engaged in anti-competitive conduct. United States v. Microsoft Corp. 2001 established that self-preferencing can be unlawful when it maintains monopoly power through exclusionary conduct. B. Incorrect. Having a large market share alone does not establish monopolization unless coupled with exclusion conduct. C. Incorrect. While consumer benefits can be a defense, consumer welfare alone does not justify anti-competitive conduct if it harms competition. D. Incorrect. International competition does not negate a monopoly claim if a company dominates the relevant U.S. market. This question tests a nuanced understanding of monopolization, focusing on technology platforms and self-preferencing in digital marketplaces. Question 3. During a seamless transition where continuity must be maintained, a large telecommunications provider plans to acquire a regional competitor. Regulatory authorities express concerns that the merger may lead to reduced competition and higher prices for consumers. Under the Clayton Act, what key factor will regulators examine to determine whether the merger should be blocked? A. Whether the merger will substantially lessen competition or tend to create a monopoly in a relevant market. B. Whether the merging companies voluntarily agree to certain conditions imposed by regulators. C. Whether the new entity will have over 50% market share in the telecommunications industry. D. Whether the merger creates jobs and contributes to economic growth. And so A. Whether the merger will substantially lessen competition or tend to create a monopoly in a relevant market. Explanation. The Clayton Act, Section 7 prohibits mergers and acquisitions that substantially lessen competition or tend to create a monopoly. Regulators such as the Federal Trade Commission, FTC, and the Department of Justice Dutch analyze the competitive effects of mergers using economic tools like the Herfindahl Indexatie. A. Correct. The key legal standard for merger review is whether the merger will substantially lessen competition or create a monopoly as per Section 7 of the Clayton Act. B. Incorrect. While merger conditions can be negotiated, they do not override the requirement that a merger must not lessen competition. C. Incorrect. Market share alone does not determine anti-competitive harm. Competitive effects analysis considers barriers to elimination of potential competitors and price impacts. D. Incorrect. While economic growth is important, antitrust law prioritizes preserving market competition over job creation considerations. This question helps students grasp merger analysis under the Clayton Act, emphasizing competitive effects, regulatory scrutiny, and economic assessment in telecommunications mergers. Question 4. In a high-stakes environment where multiple challenges must be addressed simultaneously, a multinational technology firm is accused of monopolistic practices under Section 2 of the Sherman Act. The firm has a dominant position in the digital advertising market where it controls over 80% of online ad sales. Competitors claim that the firm has engaged in exclusionary conduct by requiring advertisers to use its proprietary ad platform in order to access its search engine's premium advertising space. Additionally, the firm has been accused of using algorithmic adjustments to prioritize its own products over competitors in search results. The firm argues that its actions are pro-competitive and result in greater efficiencies. Which of the following best describes how courts are likely to analyze this case under U.S. Antitrust law? A. The court will apply the per rule, as monopolization cases always result in a finding of liability if the defendant holds a dominant position. B. The court will apply a rule of reason analysis assessing both the firm's alleged exclusionary conduct and its pro-competitive justifications. C. The firm will not face liability because controlling a large market share alone is not enough to violate antitrust laws. D. The firm's act constitute an essential facilities doctrine violation, automatically leading to finding of antitrust liability. Answer. B. The court will apply a rule of reason analysis assessing both the firm's alleged exclusionary conduct and its pro-competitive justifications. Explanation. Under Section 2 of the Sherman Act, 1890, monopolization requires two key elements: possession of monopoly power in the relevant market, the willful acquisition or maintenance of that power through exclusionary or anti-competitive conduct rather than through superior products, but acumen or historic accident. Courts generally analyze monopolization cases using the rule of reason, which assesses whether the firm's conduct harms competition more than it benefits consumers. In United States v. Microsoft Corp. 2001, the court found that Microsoft's restrictive licensing and exclusionary tactics harmed competition and violated antitrust law. Option A is incorrect because the per rule applies mainly to horizontal restraints, e.g., price fixing and bid rigging, not monopolization cases. Option C is misleading because while market share alone is insufficient for liability, exclusionary conduct that maintains dominance can lead to a violation. Option D is incorrect because the essential facilities doctrine is rarely applied and courts have been reluctant to impose mandatory access requirements. Question 5. When implementing new protocols in a shared environment, a group of pharmaceutical companies is investigated for potential violations of Section 1 of the Sherman Act. The companies, which collectively hold over 70% of the market for generic insulin, allegedly agreed to restrict supply, leading to higher prices. They argue that their agreement was necessary to stabilize production and ensure long-term availability of insulin. Legal standard will courts most likely apply to determine whether this agreement violates antitrust law? A. Per legality, as agreements to restrict supply among competitors are inherently anti-competitive. B. Rule of reason analysis, requiring an evaluation of both the anti-competitive effects and any pro-competitive justifications. C. No violation exists because companies have the right to limit their production to maintain profitability. D. The quick look standard, as courts will presume the agreement is anti-competitive but may Justifications. Answer A. Per-legality, as agreements to restrict supply among competitors are inherently anti-competitive. Explanation. Under Section 1 of the Sherman Act, agreements between competitors that unreasonably restrain trade are illegal. Courts classify restraints into three categories. Per illegal, practices that are always anti-competitive, such as price fixing, market allocation, and supply restrictions. Rule of reason. Cases where the court both anti-competitive harm and pro-competitive justifications. Quick look analysis. Used for agreements that seem anti-competitive on their face but may have plausible justifications. Supply restrictions among competitors are generally treated as per violations. In FTC v. Akhavis Inc. 2013, the Supreme Court held that certain agreements that limit competition, even if framed as necessary, could be illegal under antitrust laws. Option B is incorrect because rule of reason analysis is not typically used for outright supply restrictions. Option C is incorrect because profitability concerns do not justify collusion to limit supply. Option D is incorrect because the quick look standard applies to cases where some efficiency arguments exist, but outright supply restrictions are considered per unlawful. Question 6. During an emergency response where multiple areas are impacted, a national grocery chain is accused of engaging in predatory pricing to eliminate local competitors in disaster-stricken regions. The chain significantly lowered prices on essential goods like bottled water, baby formula, and medical supplies, selling them below cost for an extended period. Competitors claim this tactic forces them out of business, allowing the chain to monopolize the market once smaller firms exit. Which of the following best describes how this case would be analyzed under antitrust law? A. Predatory pricing is per illegal under Section 2 of the Sherman Act. B. Courts require evidence that the firm both priced below cost and had a dangerous probability of recouping its losses through monopoly pricing. C. There is no violation, as companies are free to set their own prices in response to emergencies. D. The chain could be guilty under the Robinson-Patman Act if price discrimination among customers is proven. Answer B. Courts require evidence that the firm both priced below cost and had a dangerous probability of recouping its losses through monopoly pricing. Explanation. Predatory pricing is a complex legal issue under Section 2 of the Sherman Act. Courts use the two-pronged Brooke Group test from Brooke Group Limited v. Brown and Williamson Tobacco Corp. 1993. The defendant must sell below an appropriate measure of cost, typically a variable cost. There must be a dangerous probability of recouping losses by later raising prices after competitors exit. Option A is incorrect because predatory pricing is not per illegal. It must meet the two-pronged test. Option C is incorrect because while companies have pricing discretion, selling below cost to eliminate competition can violate antitrust law. Option D is incorrect because the Robinson-Patman Act focuses on price discrimination between buyers, not predatory pricing. This case would hinge on whether the grocery chain had realistic strategy to recover losses after forcing rivals out. Question 7. In a rapidly evolving industry where innovation is a key factor, a leading semiconductor manufacturer is accused of engaging in exclusive dealing arrangements that allegedly harm competition. The manufacturer requires computer manufacturers to source at least 90% of their processors exclusively from its brand in exchange for significant discounts and rebates. Smaller competitors argue that these arrangements foreclose from a substantial portion of the market, making it impossible for them to compete. How would a court likely analyze this claim under U.S. antitrust law? A. The court will apply the per rule, as exclusive dealing contracts automatically constitute anti-competitive conduct. B. The court will apply a rule of reason analysis to determine whether the exclusivity agreement substantially foreclose competition. C. No violation exists because manufacturers are free to choose their suppliers based on price incentives. D. The plaintiff must prove that the manufacturer explicitly intended to drive out of business for liability to arise. Answer B. The court will apply a rule of reason analysis to determine whether the exclusivity agreement substantially foreclose competition. Explanation. Exclusive dealing arrangements are generally analyzed under the rule of reason rather than the per rule. Courts consider the percentage of the market foreclosed to competitors, the duration and scope of the agreements, whether the exclusivity enhances efficiency or simply harms competition. In Tampa Electric Company v. Nashville Coal Company, 1961, the Supreme Court ruled that exclusive dealing is illegal only if it forecloses a substantial share of the market. If a dominant firm's exclusivity contracts significantly restrict rival access to key customers, they may violate Section 1 of the Sherman Act or Section 3 of the Clayton Act. Option A is incorrect because exclusive dealing is not per illegal. It depends on market impact. Option C is incorrect because even voluntary agreements can harm competition if they prevent entry by rivals. Option D is incorrect because antitrust liability does not require proving explicit intent. Only the effect on competition matters. Question 8. When addressing concerns about consumer choice in the marketplace, a major online retailer is investigated for engaging in self-preferencing practices. The retailer operates a marketplace platform where third-party sellers list their products, but also sells its own private label brands. Internal documents reveal that the retailer systematically ranks its own products higher in search results, even when competitor products have reviews and lower prices. The retailer defends its actions by stating that it optimizes search results for consumer convenience. How would this case likely be analyzed under antitrust law? A. The retailer is violating antitrust laws because favoring its own products always constitutes an abuse of dominance. B. Courts will apply a rule of reason analysis to determine whether the self-preferencing conduct harms consumer welfare. C. No violation exists because the retailer is entitled to control its own platform as it sees fit. D. The conduct is automatically illegal under the Essential Facilities Doctrine. Answer. B. Courts will apply a rule of reason analysis to determine whether the self-preferencing conduct harms consumer welfare. Explanation. Self-preferencing by dominant firms is a growing antitrust concern, particularly in digital markets. Courts assess these cases using the rule of reason, considering whether the platform's conduct excludes rivals unfairly or is justified by efficiency, whether self-preferencing harms consumer choice and competition. Ohio v. American Express Company, 2018, the Supreme Court emphasized that courts must analyze multi-sided markets by considering both merchant and consumer impacts. If self-preferencing harms competition more than it benefits consumers, it could violate Section 2 of the Sherman Act. Option A is incorrect because self-preferencing is not per illegal. It depends on competitive effects. Option C is incorrect because controlling platform does not give firm unlimited power to exclude rivals. Option D is incorrect because the Essential Facilities Doctrine is rarely applied in modern antitrust law. Question 9. During a regulatory review where compliance is the central focus, an international airline is accused of engaging in predatory pricing on key international routes. Competitors claim that the airline significantly reduces fares below operating costs whenever a new airline enters the market, only to increase prices again once the competitor exits. The airline argues that its pricing decisions are a legitimate response to competition. Would a court likely evaluate this claim? A. The airline's pricing is per illegal under the Sherman Act because it lowers prices to drive out competitors. B. The airline must prove that it is operating at loss to avoid liability under predatory pricing laws. C. The court will apply the Brooke Group test, requiring proof that the airline priced below cost and has probability of recouping its losses. D. There is no violation because businesses are allowed to change prices based on market conditions. Answer C. The court will apply the Brooke Group test, requiring proof that the airline priced below cost and has a probability of recouping its losses. Explanation. Predatory pricing cases are evaluated under the Brooke Group test, which requires proof that the defendant priced below an appropriate measure of cost, usually average variable cost. The defendant had a dangerous probability of recouping its losses through future monopoly pricing. Matsushita Electric Industrial Company v. Zenith Radio Corp. 1986, the Supreme Court held that predatory pricing is difficult to prove because low prices can benefit consumers. The key issue is whether the airline can later recover losses by raising prices after eliminating competition. Option A is incorrect because predatory pricing is not illegal. It must meet the two-pronged test. Option B is incorrect because simply proving losses is not enough. Plaintiffs must show intent to monopolize. Option D is incorrect because while price changes are allowed, sustained below-cost pricing that eliminates rivals can be illegal. Question 10. In a case where long-term competitive effects must be considered, a large telecommunications company is challenged for implementing a most favored nation (OMN) clause in its contracts with content providers. The MFA clause requires content providers to offer the telecom company the lowest prices and best terms available in the market. Competitors argue that these clauses prevent smaller providers from negotiating better, leading to reduced competition. The telecom company defends its practice by stating that MFN clauses ensure fair pricing for consumers. How would a court likely evaluate this claim? A. The court will apply a per rule, as MFN clauses always reduce competition. B. The court will apply the rule of reason, weighing both anti-competitive and pro-competitive effects. C. No violation exists because MFN clauses are common and do not inherently harm competition. D. The company must prove that the MFN clause benefits consumers to avoid liability. Answer: B. The court will apply the rule of reason, weighing both anti-competitive and pro-competitive effects. Explanation: most favored nation (MFN) clauses are typically evaluated under the rule of reason, which examines whether MFN clauses deter price competition by preventing rivals from securing better terms, whether they create barriers to entry by locking up key suppliers, whether they have pro-competitive benefits such as transaction costs. In United States v. Apple Inc. 2013, the judge challenged Apple's MFN clauses with e-book publishers, arguing that they raised prices and harmed competition. Courts generally do not consider MFN clauses illegal, but they can be problematic if they limit market access for competitors. Option A is incorrect because MFN clauses are not automatically illegal. Their effects vary. Option C is incorrect because while MFN clauses are common, they can still violate antitrust laws in certain contexts. Option D is incorrect because the burden is on plaintiffs to show harm, not on defendants to prove benefits. Question 11. During a regulatory review where compliance is the central focus, a multinational technology firm is investigated for its data privacy practices. The company collects extensive user data, including browsing history and purchasing behavior, to personalize advertisements. Regulators allege that the firm fails to provide users with meaningful control over their data, violating consumer protection laws. The company argues that data collection practices are essential for improving user experience and providing free services. How would regulators likely assess this issue under consumer protection and privacy laws? A. The regulators will apply a per rule, as collecting user data without consent is always illegal. B. The regulators will examine whether the company provides adequate transparency and user control over data collection. C. No violation exists because users agree to the terms of service when signing up. D. The company must prove that its data collection provides net benefits to consumers. Answer: B. The regulators will examine whether the company provides adequate transparency and user control over data collection. Explanation: data privacy laws, such as the General Data Protection Regulation (GDPR) and the California Consumer Privacy Act (CPA), require companies to clearly disclose how they collect and use data, allow users to opt out of data collection, ensure data security to prevent misuse, regulate, assess whether the firm provides transparent, informed consent and adequate opt-out mechanisms. In FTC v. Facebook 2019, the FTC fined Facebook $5 billion for deceptive privacy practices. Courts consider whether users understand how their data is used, whether the company gives meaningful control over data settings. Option A is incorrect because not all data collection is illegal, only deceptive or coercive practices. Option C is incorrect because terms of service alone do not exempt companies from privacy laws. Option D is incorrect because consumer harm outweighs business benefits if privacy rights are violated. Question 12. In a rapidly evolving industry where innovation is a key factor, a pharmaceutical company patents a groundbreaking drug and sets its price significantly higher than similar treatments. Critics argue that the pricing strategy exploits patients and limits access to essential medicine. The company defends its decision by stating that high prices are necessary to recover research and development costs. How would regulators analyze this pricing? Antitrust and consumer protection laws. A. The company is violating antitrust laws because high prices automatically indicate abuse of market power. B. Regulators will evaluate whether the pricing reflects monopolistic behavior that restricts consumer access. C. No violation exists because patent holders have absolute pricing control. D. The company must prove that its research costs justify the high price to avoid penalties. Answer: B. Regulators will evaluate whether the pricing reflects monopolistic behavior that restricts consumer access. Explanation: Pharmaceutical pricing is evaluated under antitrust law and consumer protection principles, considering whether the firm has market exclusivity due to patents, whether pricing prevents consumer access to essential drugs, whether the company engages in anti-competitive conduct such as pay-for-delay agreements. FTC v. Activist 2013, the Supreme Court ruled that agreements delaying generic competition can violate antitrust laws. Excessive pricing alone is not illegal, but if high prices result from anti-competitive behavior, regulators may intervene. Option A is incorrect because high prices alone are not an antitrust violation. Option C is incorrect because patent rights do not grant unlimited pricing power. Option D is incorrect because companies do not have to prove R and D costs to justify prices. Question 13. In a high-stakes business negotiation where competitive advantage is a priority, two telecommunications companies discuss a potential merger. The companies argue that combining their operations will increase efficiency and improve network coverage for consumers. However, regulators express concerns that the merger will reduce competition, leading to higher prices and fewer choices for consumers. What factors will regulators consider determining whether to approve or block the merger? A. Only whether the merger will create immediate job losses. B. The potential reduction in market competition and consumer harm. C. Whether the new company will be more profitable post-merger. D. The total revenue generated by both companies before merging. Answer B. The potential reduction in market competition and consumer harm. Explanation. Regulators such as the Federal Trade Commission (FTC) and the Department of Justice Dutch analyze mergers under antitrust laws, focusing on market concentration. Will the merger significantly reduce competition? Consumer impact. Will it lead to higher prices or lower service quality? Barriers to entry. Will new competitors struggle to enter the market? In United States v. AT&T 2011, the Dodge sued to block AT&T's merger with T-Mobile, arguing that it would reduce competition and harm consumers. Courts assess whether the merger will result in monopolistic control or anti-competitive behavior. Option A is incorrect because job losses are not the primary focus of antitrust law. Option C is incorrect because profitability does not justify reduced competition. Option D is incorrect because total revenue does not determine competitive effects. Question 14. During an economic downturn where financial stability is a widespread concern, a major investment bank faces liquidity issues and considers selling risky mortgage-backed securities to retail investors. The bank argues that these securities have potential for high returns, but financial analysts warn that they carry significant default risk. How would regulatory agencies likely evaluate the bank's actions under securities laws? A. The bank can sell these securities without restriction as long as they disclose potential risks. B. The sale of high-risk securities to retail investors could violate consumer protection and securities laws. C. The bank must obtain government approval before selling securities. D. If investors lose money, they cannot hold the bank responsible. Answer. B. The sale of high-risk securities to retail investors could violate consumer protection and securities laws. Explanation. Regulators such as the Securities and Exchange Commission (SEC) enforce laws to protect investors from deceptive practices. The sale of high-risk financial products to unsophisticated retail investors may violate the Securities Act of 1933, which requires transparency in financial disclosures. The Dodd-Frank Act, which prevents misleading financial practices. In SEC v. Goldman Sachs 2010, the SEC fined Goldman Sachs for misleading investors about mortgage-backed securities. Regulators assess whether risk disclosures were clear and sufficient, whether the bank targeted investors who lacked financial expertise. Option A is incorrect because simply disclosing risks does not eliminate liability if deception occurs. Option C is incorrect because government approval is not required for every security sale. Option D is incorrect because investors can sue for misleading information. Question 15. In a dispute over intellectual property rights where innovation is at stake, a small startup accuses a multinational corporation of copying its patented software technology. The startup claims that the corporation used its patented algorithm without permission to develop a competing product. The corporation argues that the patent is too broad and should be invalidated. How would a court likely analyze this case? A. The court will immediately invalidate the startup's patent if the corporation challenges it. B. The court will assess whether the corporation's product infringes on valid patent. C. The startup has no legal recourse because larger companies have more resources for innovation. D. The corporation will automatically win if it can prove it did not copy the software directly. Answer B. The court will assess whether the corporation's product infringes on valid patent. Explanation. Patent infringement cases involve evaluating patent validity. Is the patent novel, non-obvious and useful? Infringement analysis. Does the corporation's product use key elements of the patented invention? Doctrine of equivalence. Even if an exact copy does not exist, does the new product perform the same function in substantially similar way? In Apple v. Samsung 2012, Apple sued Samsung for copying smartphone design patents. Court ruled in favor of Apple, awarding damages. Option A is incorrect because patents are not automatically invalidated upon challenge. Option C is incorrect because small companies can enforce patents against larger firms. Option D is incorrect because direct copying is not required for infringement. Question 16. During a congressional hearing where ethical concerns are being debated, lawmakers question a leading social media company about its handling of user-generated content. Critics argue that the platform allows harmful misinformation to spread unchecked, while the company claims that it cannot censor users without violating free speech rights. What legal and ethical factors influence how governments regulate online content? A. Governments must allow all speech, including harmful misinformation, to protect free expression. B. Platforms have a responsibility to moderate harmful content while respecting free speech. C. Social media companies have no legal responsibility for user content. D. Misinformation is only a problem if it leads to physical harm. Answer B. Platforms have a responsibility to moderate harmful content while respecting free speech. Explanation. Social media platforms operate under Section 230 of the Communications Decency Act, which protects them from liability for user content. However, platforms are expected to prevent harmful misinformation, e.g., election interference, health misinformation, enforce community guidelines while respecting rights. In Facebook and Twitter hearings 2021, Congress questioned whether platforms should be held accountable for failing to moderate harmful content. Courts balance First Amendment rights, protecting speech from excessive government restriction, consumer protection laws, ensuring platforms do not enable harm. Option A is incorrect because governments can regulate speech that causes significant harm, e.g., fraud, defamation. Option C is incorrect because companies can be held accountable for failing to enforce policies. Option D is incorrect because misinformation can be harmful even if it does not cause direct physical harm. Question 17. In a complex international trade dispute where economic sovereignty is contested, a nation imposes high tariffs on imported electronics to protect its domestic industry. In response, affected trading partners retaliate with their own tariffs, leading to rising costs for businesses and consumers. What legal and economic considerations influence how governments handle such trade disputes? A. Governments can impose any tariffs they want without consequences. B. Trade disputes are governed by international agreements, such as LOU rules, which aim to prevent unfair trade practices. C. Retaliatory tariffs are always illegal under international law. D. Domestic companies always benefit from tariffs imposed on foreign competitors. Answer B. Trade disputes are governed by international agreements, such as LOU rules, which aim to prevent unfair trade practices. Explanation. International trade disputes are typically handled under World Trade Organization agreements and bilateral trade treaties. Governments consider tariff impacts on consumers and businesses. Higher prices for goods may harm local economies. Retaliation risks. Trading partners may respond. Counter tariffs escalating disputes. Legal challenges. LOU rules prohibit discriminatory or protectionist trade policies that unfairly favor domestic industries. For example, in the U.S. China Trade War 2018-2020, the U.S. imposed tariffs on Chinese goods and China responded with its own tariffs. The LOU ruled that some U.S. tariffs violated global trade rules. Option A is incorrect because excessive tariffs can lead earlier sanctions and trade disputes. Option C is incorrect because retaliatory tariffs are not always illegal depending on trade agreements. Option D is incorrect because tariffs can increase costs for domestic businesses reliant on imported materials. Question 18. When an environmental disaster threatens public safety and corporate accountability is being debated and all companies accused of failing to follow safety protocols, leading to a major spill that contaminates marine ecosystems. The company argues that it met minimum legal requirements but acknowledges flaws in its safety measures. What legal and ethical principles guide how courts determine corporate responsibility in such A. If the company met legal requirements, it cannot be held accountable for environmental damage. B. Courts consider whether the company acted negligently, even if it followed minimum legal standards. C. Environmental protection laws do not apply to oil companies. D. The company is automatically guilty of wrongdoing whenever an oil spill occurs. Answer: B. Courts consider whether the company acted negligently, even if it followed minimum legal standards. Explanation: in environmental liability cases, courts evaluate negligence and corporate responsibility. Did the company fail to take reasonable precautions? Environmental laws, such as the Clean Water Act and Oil Pollution Act, which require responsible parties to clean up pollution. Public harm versus corporate rights. Courts assess whether damage was preventable or due to reckless business practices. For example, in the BP Deepwater Horizon spill 2010, BP was found negligent for failing to follow safety measures, leading to billions in penalties. Option A is incorrect because meeting minimum legal standards does not eliminate liability for negligence. Option C is incorrect because environmental laws apply to all industries, including oil companies. Option D is incorrect because not all spills are due to negligence. Some may be accidental despite best efforts. Question 19. In a debate over consumer data privacy where technological innovation and personal security intersect, a popular mobile app is criticized for collecting user data without explicit consent. The company argues that data collection improves user experience, while privacy advocates warn of potential misuse. What legal and ethical considerations shape policies on data privacy? A. Companies can collect any user data they want without restriction. B. Data privacy laws require companies to obtain clear consent before collecting personal information. C. Governments cannot regulate data privacy because technology companies operate independently. D. Consumers have no right to know what data is being collected about them. Answer: B. Data privacy laws require companies to obtain clear consent before collecting personal information. Explanation: data privacy is regulated under laws like the General Data Protection Regulation (GDPR) in Europe and the California Consumer Privacy Act (COPA) in the U.S., which require explicit user consent before collecting personal data. Transparency in data practices, allowing consumers to access and delete their data. Restrictions on selling or sharing sensitive data without permission. For example, in Facebook's Cambridge Analytica scandal 2018, regulators fined Facebook for improperly sharing user data without consent. Option A is incorrect because privacy laws limit data collection without consent. Option C is incorrect because governments do regulate data privacy through legislation. Option D is incorrect because consumers have legal rights to access and control their data. Question 20. When an ethical dilemma involving corporate social responsibility is at the center of public debate, a major fashion brand is accused of using factories with poor labor conditions in developing countries. The brand claims it follows all local labor laws, but investigative reports reveal that workers face unsafe conditions and extremely low wages. What factors determine corporate accountability in such situations? A. If the company follows local labor laws, it has no ethical responsibility beyond that. B. Companies are expected to follow both local laws and international labor standards to ensure ethical practices. C. Labor conditions are solely the responsibility of factory owners, not global brands. D. Consumers do not care about labor practices as long as products are affordable. Answer: B. Companies are expected to follow both local laws and international labor standards to ensure ethical practices. Explanation: corporate social responsibility (CSR) goes beyond legal compliance and includes ethical labor practices. Companies are expected to ensure fair wages and safe working conditions. International labor standards. Organizations like the International Labour Organization (ILO) set global guidelines. Brand reputation. Consumers increasingly demand ethical supply chains. In Nike's sweatshop scandal 1990s. Reports of poor labor conditions forced the company to reform its policies, showing that legal compliance alone is not enough. Option A is incorrect because companies are expected to meet higher ethical standards beyond local laws. Option C is incorrect because global brands are responsible for their supply chains. Option D is incorrect because many consumers do care about ethical sourcing. Question 21. In a high-stakes environment where multiple challenges must be managed simultaneously, a financial institution is undergoing a major cybersecurity upgrade to protect customer data. However, the upgrade risks disrupting daily banking operations. What strategic factors should be considered to balance security improvements with operational continuity? A. Prioritize security upgrades regardless of operational impact. B. Delay the upgrade until all risks can be eliminated. C. Implement security changes in phases with contingency plans for critical disruptions. D. Rely on external cybersecurity firms without internal oversight. Answer: C. Implement security changes in phases with contingency plans for critical disruptions. Explanation: cybersecurity upgrades should balance enhanced security, business continuity, and risk management. Strategies include phased implementation to minimize disruptions, backup systems to ensure continuous access to banking services, cross-department collaboration to align security protocols with business operations. For example, the Equifax data breach 2017 failure to apply security patches in time led to massive data theft. A structured, phased approach could have prevented this. Option A is incorrect because disrupting operations could harm customers and financial stability. Option B is incorrect because delaying upgrades indefinitely increases cyber attack risks. Option D is incorrect because organizations must maintain internal security governance. Question 22. During a comprehensive review of a process that needs improvement, a global manufacturing company finds that product defects have increased after automation was introduced. While automation has improved efficiency, quality control issues persist. What steps should be taken to resolve this problem? A. Remove automation and return to manual processes. B. Improve automation by integrating better quality control mechanisms. C. Continue with automation despite defects, expecting workers to adapt. D. Ignore defects and focus solely on production speed. Answer: B. Improve automation by integrating better quality control mechanisms. Explanation: automation should enhance both efficiency and quality. Solutions include AI-powered quality control systems to detect defects in real time, routine calibration of automated machinery to prevent errors, employee training to work alongside automation effectively. For example, Toyota's lean manufacturing model balances automation with oversight to maintain high quality. Option A is incorrect because removing automation reduces efficiency. Option C is incorrect because ignoring quality issues damages brand reputation. Option D is incorrect because defective products harm customer trust. Question 23. When implementing new protocols in a shared environment where compliance varies, a multinational healthcare organization is rolling out updated patient privacy regulations. However, regional offices follow different data protection standards. How should leadership ensure uniform compliance? A. Allow each office to follow its own standards. B. Enforce a global policy but provide region-specific adaptations. C. Ignore local regulations and apply only the strictest policy worldwide. D. Let each department decide on its own level of compliance. Answer: B. Enforce a global policy but provide region-specific adaptations. Explanation: global organizations must align policies with local regulations while maintaining core standards. Harmonized compliance frameworks ensure consistency and legality. Training programs educate employees on both global and local policies. Regular audits verify adherence. For example, GDPR Europe and HIPAA US require different privacy protections, so multinational companies adapt policies accordingly. Option A is incorrect because inconsistent policies lead to legal and security risks. Option C is incorrect because one-size-fits-all policies may violate local laws. Option D is incorrect because decentralized compliance creates vulnerabilities. Question 24. In an environment where different components must interact efficiently, a logistics company faces delays due to communication gaps between its warehouse and transportation teams. What strategies can improve coordination and reduce inefficiencies? A. Implement real-time tracking and automated updates. B. Increase paperwork requirements for documentation. C. Extend delivery deadlines without changing processes. D. Rely on verbal communication rather than digital tools. Answer: A. Implement real-time tracking and automated updates. Explanation: seamless logistics requires technology-driven coordination. Real-time tracking provides visibility into delivery schedules. Automated alerts reduce manual errors. Integrated platforms ensure warehouse and transportation teams access the same data. For example, Amazon's logistics network relies on AI and automation to optimize delivery efficiency. Option B is incorrect because excess paperwork slows operations. Option C is incorrect because delays impact customer satisfaction. Option D is incorrect because digital tools improve accuracy and speed. Question 25. While analyzing the root causes of sequential problems in an infrastructure, a technology firm notices recurring system failures despite previous fixes. What approach should be taken to prevent future incidents? A. Conduct a thorough root cause analysis before applying fixes. B. Apply quick fixes without investigating the root issue. C. Replace all systems without diagnosing the problem. D. Ignore failures and hope they resolve themselves. Answer: A. Conduct a thorough root cause analysis before applying fixes. Explanation: root cause analysis (RCA) identifies underlying problems rather than just treating symptoms. Analyzing failure patterns helps prevent repeated incidents. Proactive monitoring detects issues before they escalate. Collaboration across its teams ensures comprehensive solutions. For example, Google's Site Reliability Engineering (SRE) approach emphasizes preventive problem-solving over reactive fixes. Option B is incorrect because temporary fixes lead to recurring failures. Option C is incorrect because replacing systems is costly and may not solve the issue. Option D is incorrect because ignoring failures worsens the problem. I'll continue with more questions. Let me know if you want any modifications. Question 26. During an emergency response where multiple areas are impacted, a hospital network experiences a cyber attack that disrupts access to patient records. What steps should be prioritized to ensure both patient safety and data security? A. Immediately shut down all hospital systems to prevent further attacks. B. Implement contingency plans to allow critical operations while securing systems. C. Pay the ransom to regain access to patient records as quickly as possible. D. Ignore the attack and continue normal operations. Answer: B. Implement contingency plans to allow critical operations while securing systems. Explanation: hospitals must balance cybersecurity and patient care. Activate backup systems to maintain access to essential patient data. Isolate compromised networks to limit the attack spread. Follow incident response protocols to secure systems without disrupting critical care. For example, in the 2020 Universal Health Services cyber attack, hospitals with strong contingency plans continued operating with minimal disruptions. Option A is incorrect because shutting down all systems can endanger lives. Option C is incorrect because paying ransoms does not guarantee recovery. Option D is incorrect because ignoring an attack worsens security risks. Question 27. In a situation where formal requirements conflict with operational realities, the construction company struggles to meet safety regulations while maintaining project deadlines. How should management address this challenge? A. Prioritize safety compliance while optimizing workflow efficiency. B. Ignore safety regulations to speed up construction. C. Request exemptions from safety laws. D. Delay the project indefinitely to avoid penalties. Answer: A. Prioritize safety compliance while optimizing workflow efficiency. Explanation: construction safety and efficiency must go hand in hand. Streamline safety protocols to minimize workflow disruptions. Use technology, e.g. real-time safety monitoring, to enhance compliance. Adjust project timelines based on risk assessments. For example, OSHA regulations protect workers, and companies that integrate safety into planning both injuries and delays. Option B is incorrect because neglecting safety can cause legal and ethical issues. Option C is incorrect because exemptions undermine worker protection. Option D is incorrect because indefinite delays hurt business viability. Question 28. While examining inconsistencies across various units in a financial firm, leadership finds that different departments interpret compliance rules differently. What steps should be taken to establish uniformity? A. Implement centralized compliance training and standardized policies. B. Allow departments to maintain their own interpretations. C. Enforce strict penalties without clarifying expectations. D. Ignore inconsistencies as long as operations continue. Answer A. Implement centralized compliance training and standardized policies. Explanation: standardized compliance ensures regulatory consistency and risk management. Develop clear policies applicable across departments. Conduct training to ensure a shared understanding of rules. Use compliance software to track adherence and prevent violations. For example, financial institutions follow strict SEC and FINRA regulations. Lack of consistency can lead to audits and fines. Option B is incorrect because different interpretations create compliance risks. Option C is incorrect because penalties without guidance do not solve issues. Option D is incorrect because ignoring inconsistencies leads to legal problems. Question 29. When scaling up operations that experience significant bottlenecks, a technology company faces delays in software deployment due to inefficiencies in its development pipeline. What measures should be taken to optimize performance? A. Automate repetitive tasks and streamline workflows. B. Hire more developers without changing the existing processes. C. Extend project deadlines without addressing inefficiencies. D. Abandon existing systems and restart development from scratch. Answer A. Automate repetitive tasks and streamline workflows. Explanation: efficient scaling requires process optimization and automation. SICT continuous integration, continuous deployment tools accelerate development. Automating testing and deployment reduces manual errors. Agile project management improves collaboration and adaptability. For example, Netflix's DevOps model uses automation to deploy updates without bottlenecks. Option B is incorrect because adding developers without process changes does not fix delays. Option C is incorrect because extending deadlines does not resolve inefficiencies. Option D is incorrect because restarting is costly and unnecessary. Question 30. During a seamless transition where continuity must be maintained, a retail company upgrades its point-of-sale system across all locations. How can leadership ensure minimal disruption? A. Roll out the system gradually while providing training. B. Replace the system immediately without preparation. C. Implement the new system but disable all backups. D. Allow each store to decide whether to switch systems. Answer A. Roll out the system gradually while providing training. Explanation: seamless transitions require phased implementation and training. Gradual deployment minimizes risks. Backup systems ensure operations continue if issues arise. Employee training enhances adoption and prevents errors. For example, Starbucks phased in mobile payments to avoid customer service disruptions. Option B is incorrect because immediate replacement causes confusion. Option C is incorrect because removing backups risks data loss. Option D is incorrect because inconsistent systems create operational chaos.